Today's final session will be moderated by Junior Lecturer Mick Marham. Mick Marham is a Junior Lecturer for Corporate Law and Social Enterprise Clinic at JSW School of Law. Before joining JSW School of Law, she worked as a Senior Legal Officer at Bhutan Alternative Dispute Resolution Center. She completed her law degree from the CMR Law School under Karnataka State Law University, Bangalore. She completed her postgraduate diploma in national law, PGDNL, in 2018 from Royal Institute of Management. She has served as a panelist for Alternative Dispute Resolution Act of Bhutan 2013 talk show hosted by Bhutan Broadcasting Service. She was a drafting member of the first ADR rules and regulations. She represented Bhutan ADR Center in Dhaka, Bangladesh, for training on alternative dispute resolution organized by Bangladesh International Arbitration Center in 2019. She is also a certified mediator by Bhutan National Legal Institute in 2017. Now, I would like to invite moderator Mick Marham to take over the final session for a day. Thank you.
Thank you, Sewang. Good evening, everyone. I'm back now as a moderator for the session 8 for the day. Before I begin to introduce our panelists here, I would like to join the nation again for wishing 42nd birth anniversary to His Majesty the King. And also thank you so much for being in such a risky area these days. Thank you. For the first presenter or the first panelist that we have for the today is Dr. Karma Siving, who is currently working as a senior court registrar, assisting the Justice of Cutting Bench. So he began as a court registrar at Thimphu District Court, Bench 2, and leading the registry division. He was responsible for the case management and assignment, facilitating the administration of justice. He assisted judges from summoning parties to hearing the cases and enforcing the judgment. He also served as the interim administrative officer and researcher at the Supreme Court. He holds a PhD in law from University of Queensland, Australia, Master of Arts in International Law, MIL, from the University of St. Gallen, Switzerland, and he completed his postgraduate diploma in national law from RIM, and completed his LLB from Nalsa University of Law, India. Now, I would like to hand over the floor to Dr. Karmala.
La sukuzambola, sensubagala. Las kariche. Kuzambola. Good afternoon, ladies and gentlemen. First of all, I wish to offer my heartfelt best wishes to His Majesty the King on his 42nd birth anniversary. Thank you, JSW Law School and the organizing team for allowing me to present at this very important first ever conference on public contracts. I hope you're sharing my slides.
Yes, I'll request the ICT team to share the slides immediately.
Yes, thank you. Like I mentioned, I've slightly changed the title of my presentation to analyze few recent decisions of the Supreme Court to gain or provide some insight into the public contract. This seems to be the one which I've submitted earlier, not the one I have given to you, I think.
So
this doesn't seem to be the latest copy.
Is this? Sir?
Yeah.
So
I've
so
sent
it's
you
taking a
a
bit of
few minutes
time.
before. It's okay.
Okay. We will have it shared immediately.
Yes.
Okay, it's with the IT team now.
Yes.
So we're sharing it. What is the title of the presentation, Dana?
There's a slight change. Before it was selected public country cases of Supreme Court. Now I have changed to recent decisions of Supreme Court insights into public
Okay.
country
Yes,
issues.
this is
This seems to be the correct one. Yeah.
this is the one.
Yeah. So basically, I will be presenting for recent decisions of the Supreme Court, so to provide or gain some insight into the public country issues. I will do that. Next slide, please. I will do that in 3 parts. First, I will have a few words on the methods and limitation, followed by the analysis of 4 recent decisions to provide insights into public country issues under the third part of my presentation. So next, please. Next slide, please. Yeah. Of course, my small attempt to present at this conference provides an opportunity to explore or look at the judicial experiences of public country law, if you will. But I must confess, my attempt to explore this unexplored legal arena is, of course, based on the 4 recent public contract decisions of Supreme Court rendered in 2021. They were randomly chosen. It is not necessary from one bench, or is it a reflective of all the benches? The choice was intentional. First, as the highest court, its decisions are fundamental in the development of jurisprudence in any field of law. Second, as I work there, it's easier for me to access the data than others, not in terms of privilege or a matter of confidentiality, but in terms of mere proximity. And for all practical purposes, it's difficult for me to collect and mug in all cases in this short presentation. So with these few words on the methods and limitation, let me crash through the 4 recent decisions of the Supreme Court. Next, please. The first case that I looked at was that of a Kebab Construction Private Limited, abbreviated as KC, versus the ABB India Private Limited, abbreviated as ABB. It was basically a case of breach of contract between the private parties that originated in Thimphu District Court and came on appeal until Supreme Court. It was a private case in the sense that the dispute was between the private 2 individuals entities, but essentially a public contract, because in this case, it concerned a subcontract of work awarded to ABB to KC, and later ABB terminated the contract on the ground that Kebab Construction failed to perform, and later KC sued ABB for terminating the contract and claimed certain damages. Both the District Court and High Court held that the breach of contract originated in ABB's failure to provide map and drawing on time. During the case, the Kebab Construction argued that the first drawing to commence the work was provided to them only after 5 months from the date of signing the agreement, and the final map or drawing was provided to them after not days or months, but after 14 months from the final date of the on which or before which the work was supposed to be completed as per the agreement. So on the appeal, the Supreme Court upheld both the District Court and the High Court's decision. Per se, if you look at this decision, it might be just a decision, but if you look at closely at this decision, it involves or affects the public interest. To me, at the least, all the parties, including the brokering agency, the Bhutan Power Corporation Limited, failed at the cost of public interest. Next, please. And the second case that I looked at was that of Tseringwangdi versus National Resource Development Corporation Limited. It was a case in which Serongdi was awarded a work to construct a staff quarter for NRDCL staff in Samtup Jonker for 1.7 million. But pending the work completion, the contractor left the work and refused to complete it despite repeated notice. Against this, the NRDCL proceeded to recover the money that was paid in excess to the contractor and also to recover penalty that was imposed by the audit. On the other hand, the contractor argued that he executed about 2.4 worth calculated as per bills of quantity and be compensated accordingly. On appeal, the Supreme Court upheld the decision of Jongkok and High Court, and the court held that because the contractor failed to complete the work on time, the contractor had to return what he received in excess. The courts found that assessment of the value of the work done was duly done as per the practices, and the contractor had to return whatever he received in excess. But all the courts dismissed the NRDCL's plea to recover the penalty that was imposed upon the excess payment by the audit. Now, from this case, we can start to appreciate that proceeding before the regular court, be it any other court cases, and specifically in public contract cases, any contractual claims are or should be or must be limited to the contractual terms and condition. That's in some sense a precedent in this field of law. So next, please. And the third case that I looked at was that of a Tenzingal Construction versus MOWHS. This is rather looking like one of the undergrad law classes. Sorry if you're bored with the flow of information. This case was also a dispute between the two parties arising from the project delay, and the dispute was referred to the arbiter tribunal, who in turn awarded in favor of MOWHS. The company appealed to the High Court, arguing that the imposition of liquidated damages were not proper. They argued before the court that the ministry encroached into the construction site and dismantled the walls that were already completed, thereby disabling the project completion on time. On appeal to the High Court dismissed the appeal and held that nothing in the award contravened the jurisdictional questions contained in sections 81 and 85 of the Arbitration Act, nor the grounds of appeal under the section 155 of the Act, which Dr. Tenzin and Dr. Delisar covered in detail. On appeals, the Supreme Court upheld the High Court decisions and dismissed the appeal. So from this case, we can start to appreciate that coming to court to question or to appeal against the arbitral awards are limited to the grounds mentioned under section 150, and that coming to court from the arbitral tribunal is no automation kind of a right. Next, please. And the last case that I looked at was that of a Pemanam Gill versus, again, the Minister of Work and Human Settlement. This case also originated in the delay in the project completion, because of which the ministry imposed a liquidity damages for about 100 days. The parties referred the dispute to the arbitral tribunal, which held that the imposition of the ministry could not impose liquidity damages on the contractor because the delay was reasonable within the facts and circumstances of the case, in that there was an unforeseen event that unfolded during the project implementation. However, on appeal to the High Court, the High Court partially set aside the award and held that the imposition of liquidity damages was proper as the delay was not excused. So on appeal, the Supreme Court upheld the High Court decisions. From here, we can appreciate that even the arbitral tribunal should be and is bound by the law as much as the other regular courts are. So next slide, please. So looking at these decisions, a constant factor affecting the efficiency of public contracts seems to be the time. Every case seems to some extent, whether in direct or indirect terms, a story of delays. As we have seen, this seems to be a pattern. not in just these cases, but might be in other cases as well. Of course, the question is then, whose problem is it? Probably it might be wrong for us to ask ourselves if we have become so used to not being on time. But I think it is logical and reasonable to ask ourselves whether it is a problem of the procuring agency in terms of project planning, or is it the problem of contract management by both the procuring agency and the contractor. As I see it, I think the contractors, they don't seem to have a time and quality assurance plan upfront, and the project supervisors and managers from the procuring agencies doesn't seem to take their job seriously. So like they say, I think the buck stops here. And the second insight into the public contract through this decision is that every case that comes to the court is a dispute mostly. So what can the court, the judiciary do? All court can and must do is, if you will, ask for the performance. If that's not possible, then ask the defaulting party to pay damages for failing to perform. So it's that simple, mostly. Allocate the risks, assess the damages, and try to find court resolution of disputes if that's at all possible. So that's basically a job of clearing the mess. As we might agree, in public contract cases, the imposition of liquidity damages is supposedly the tool to deter delays and manage delays. But still the question is it an efficient tool? Is it too less? To me, I think looking at this cases, to some extent, it's reasonable to say that the contractors are claiming the liquidity damages, I mean, the reimbursement that is cut as a liquidity damages, 10% of the contract amount, as a matter of right. I don't think they really care, do they? So this seems to be one of the recurring issues in dealing with the delays in the public contract issues. The next is like, if you look at the case of Kabo Construction versus the ABB India Private Limited, we will see that there are inordinate and inexcusable delays caused by what? Precisely the failure of the contractor to provide the subcontractor with the map or drawing. Whose failure or who fell in this instant? Also, amongst other things, in this case, the court had to order the ABB to pay KC the 10% of the subcontract amount as mobilizing fund, which ABB, like they got it from Bhutan Power Corporation Limited, ought to have paid them at the beginning of the work. So what all of this tell me at the least is the need for managing the subcontracting by the contractors and procuring agencies. I think we will agree that subcontracting is legal, it is allowed, there's nothing wrong about it, but perhaps we might consider introducing a contract clause that benefits subcontractors generally. For example, maybe we start to have a contract clause that requires the payment of direct payment to the subcontracting contractors by the contracting or procuring agencies. So that's one of the issues that we might like to think over. And then next is more of it can be interpreted as an opportunity or in terms of challenges in proceeding before the regular courts, in that it forms a precedent that any cases, any contractual claims, whether in private or public contracts, must be within the contractual terms and condition that was entered between the parties. If you look at the Tseriwangdi versus NFDCL, the contractor claimed that the work done was more than even the overall project cost. That's something I think we will not be able to afford. And the last issues that we see while we study the cases is that in some cases the contractors, they claim that the officials are taking over months to process bill. It was promising to hear from Tandin Doji from DNP on about the new timelines for bill processing under the simplified PRR, but I think this still remains one of the concerns in the public contract law. And before I conclude, I also thought maybe perhaps you might also think of maybe think of having a central legal body like that of OAG in the field of criminal law that will contribute towards enhancing professionalism and accountability in public context. So this is it for today. Thank you for your attention.
Yes, thank you, Dr. Karma, for this wonderful presentation and taking us through 5 cases, insights of these 5 cases pertaining to the public contract. I'll definitely reserve any questions or comments at the last. So directly we will move into second panelist. For the second panelist, second speaker that we have is Mr. Sonam Rinzinda, and who is a procurement officer. He's currently working with the Thimphu Thomde. So he has a work experience of 12 years in the field of the procurement, and he graduated with the Bachelor's of Commerce from Sharapsi College, affiliated with University of Delhi, Kanglung, Latashigang. So straight away, I will hand over the floor to Sir Sonam.
Good evening. I'm audible. Hello.
Yes, sir.
Yes.
Yes, sir.
Welcome to the last session of the second day of the conference. Before I go to the presentation, I would like to thank JSW management for providing such opportunities to Thimphu Thomde, and I'm very privileged to be a part of this conference. My presentation topic is on the public procurement challenges. So I will share my presentation.
Yes, so now we also have a backup PPT out here with our ICT team.
If you can share.
Yes, thank you.
It's not working.
And request our ICT team. Sonam sir, can you please unshare that screen?
Please wait. No, I'm stuck here. Screen share mana cik?
Yes, sir, we have shared from here.
Okay, then please can you go to next slide? Hello, madam. Can you proceed lah?
Yes.
Can you change
yes,
my? Okay, next. This is my presentation outlines. What is the public procurement? I've probably there is a 6 points there to be covered. Please next. What is the public procurement? Most of the presenters have highlighted, so I don't need to express more on this. What public procurement is basically when basically it's governed by the government rules and regulation to use of the public money. So next is the objectives. I don't want to explain on this. It's already covered by our legal attending in the morning session. This is type of procurement. 3 types is already aware by the all of here. So next. This is a procurement cycle, which everybody knows. In this procurement cycles, I will explain what are the challenges faced in the field during the execution of the contract management. So next page. This is my main presentation. From here, I will begin. Public procurement challenges really emerge from here. There is 6 procurement cycles. In each procurement cycles, there is a challenges faced during the execution in the field level. First step is need identification, need analysis, which in the first day, Deputy Auditor General has clearly pointed out that the procuring agencies are neglecting or not doing those feasible study in the feasible study before the tendering or proceed with the procurement of anything. I will accept slightly, not full accept. We as a procuring agency, our aims and objectives also to provide a best service with our limited resources. When it comes to a poor feasibility studies, in the field, before we prepare any tender, we also, this is facing problem because of all lack of our equipments. To have a detailed feasibility study, one should have a set equipments, resources, facilities, and all. Even then, at our base, our site engineers are doing their best. In absence of those facilities, before they're preparing the tender documents and BOQs and all, they visited fields, and at their base, then only they develop the specification, design, and cost estimate. Then only they proceed with the tendering process. This market survey, one of the important aspects is a market survey. Market survey help us to evaluate the bid and award the contract at the best price. This also, sometimes most of our officials are directly making a requisition and to develop requisition to the procuring agency without any market survey, whether the product is available in the market and all, which after all leading to the cost overrun. For example, just for need of the simple laptop, they are going for the high-end laptop, which is costly and waste of public money. For this budget constraints, while we are in the field, we have to sometimes we have to execute the contract without having any approved budget. The work has to carry out based on the emergency and need at the public. When we carry such a contract without any budget provisions, the issue here is challenges we face over is we cannot make a timely payment. When we cannot make timely payment, the work is hampered, which is ultimately delaying the project completion. So next, going to the tendering process, tendering, poor specification developed. Yes, the officials who are in the field is also not that expert in developing this specification, which we use as this online internet and all Google's as a source to derive this specification because of the ambiguity in the evaluation criteria, which leads any procurement best, which we cannot select the best contractor or supplier. For over here, I want to share in case of the small contract, while developing the criteria, there is a SBD, standard bidding documents shared by the Minister of Finance, which is just a sample. Actually, that sample, what our contractor thought was is the standard one. This SBD is a silent whether a requirement for the HR and any human resources. while we procuring agency try to incorporate those human resource requirement like diploma engineer or some equipments which is very essential in the field. There, our contractors is challenging procuring agency that we are incorporating such criteria which is beyond the rules. So which over here we our intention is to get a best service at the end. And we are doing in the interest of the work. Over here, we have to sensitize and educate these contractors and suppliers that this standard bidding document can be amended by the procuring at the discussion of the procuring agency. Whole life costing. As a procuring officers are doing procuring anything in our agency, we also wish that and focus the life cycle costing. For example, just to procure a simple printer, most of the procuring agency are just developing a simple specification, and then we evaluate based on that. Once qualified with that technical specification, then we go for the price, which is actually not a complete. Since there is no clear guidelines and formula to derive, actually we have to look for the overrun cost life cycle, like consumption of toner. If we pay less cost for the printer at initial time, and if the cost of the toner is very huge, which will ultimately lead a very huge cost in long run. So these are the things we have to look. Unrealistic project duration. As I am being always in the tender committee as a member secretary, I used to observe that many of the cases are coming for the time extension, where I believe or I suspect that the engineers who are deriving this project duration, I don't know what aspects they are considering. Most of the time we have to deliberate on this time extension. Of course, there is the time extension is approved by our tender committee reviewing all these documents. There is also a force majeure clause in the PRR. After considering, still I felt that there are some loopholes. How they are determining this project timeline. During this, now we'll go to point number 3, evaluation. As in the procuring agency, we felt very difficult to determine this best evaluated bidder. Over here, just to quote a simple example, like if we tender out for one small contract, let's say small, we used to receive more than 30 to 40 bidders. While evaluating that bids, most of them will be, their quoted price will be 30 to 25% below our estimated cost. Of course, there is a clear guidelines in our PRR that to review our estimates and ask the rated analysis and all. All these are being exercising by our evaluation committee and putting up to the tender committee for the final approval. Is still, for example, if a bidder has quoted 20%, first bidder and second bidder 19 and third bidder 22% below our estimate quote, we are very difficult in determining which is best. As 20% in abnormally 20% of below our estimate in PR is just a syndication that is abnormally low, but there is no specific percentage how much is considered to be abnormally low. In this case, while evaluating, if we award to this the 19% low, and there is a second bidder 20%, there's just a 1% difference. So finally, we are landing up to award to the financially lowest price only. So these are the really challenging job that our teams are doing in the field. Next slide. This after sales service. This is the one criteria that we are incorporating in the bid evaluation criteria. This is just to eliminate those brief business. We have experienced before. Over here, we examine the availability of their shops and establish self-service centers like that to ensure the backup services. So we have also experienced that there are some suppliers who are working over the phone. Once they complete supplying their goods, then they vanish. We cannot catch up for the backup services. So this after sale service, we consider as one of the important evaluation criteria. During the contract award, as I have already explained that one, so we mostly our time lose is this contractor or supplier grievances. Since the government has given a platform letter as a letter of intent 10 days, now contractors or suppliers, they are taking this as a right, whether they have a valid reason or a substantial reason, they used to accuse the procuring agency for our evaluation reports, which we mostly waste our time on explaining and calling. And after all, they are also appealing to the higher bodies like IRB, SSC, and all. So we use normal waste a lot of time here. These are some of the challenging jobs that we are facing. Next is a contract management, timely intervention and monitoring. This, as auditor is pointing out, I also felt that our PI unit, project implementation unit, seems a little inactive. So over here, our tender committee in Tromde, we are also hunting those site engineers to submit all those reports timely. So we have kept once in a week to present all those physical updates of works and financial progress report. So our team also visit along with the site engineer. What we observe here is the main reason we've challenging facing over here is one engineer is handling more than 4 or 5 projects. So this is one. Seems to be overloaded. And the front loading bits, we in the field there are some contractors who have executed the works which is profitable one before there is the build through running bill there, and they claim that. So later on, when certain percent of the works to be completed, they ran away. So these are the some of challenge. Even we forfeit their performance guarantee and this contractor, there's no much impact since the contractors are very smart. They have already calculated and doing that. So even we divert or exclude these contractors in our agency, they are coming in another form in their relatives, which actually it is affronting in relatives license and all. Next, please.
Last Sonam sir, I want you to wrap up because
okay, this is the last slide. Poor implementation of the contract terms over here. Our people over has as his ministry is clearly addressing during their national drill. We are making very clear terms and conditions, but very poor implementation in a field. For example, in our contract documents, we used to incorporate that as we wanted this many degree engineer, diploma engineer, and site supervisor. But when we actually visit to the field, the contractor is saying that these as large contractor are eligible for the more than 2. They are eligible for up to 5 projects. They are excusing that their engineers are here and there. So these are the real challenges that we face. Lack of accountability is already covered by some of the, and lack of quality assurance tool. This is the main thing we are facing. We don't have any equipments to check. Of course, for the ICT equipments in our agency, we used to involve those ICT experts, and for those technical goods, we also involve those engineers and all. These are the challenges that face in our agency, and all those are not based on my experience and my opinion only. There is no any research on this. Thank you, madam.
Sonam sir, thank you so much for your wonderful presentation on the public procurement challenges and basically your experiences in the field that you have faced while tendering out or bid evaluation and all those things. So now that we will take a question from our audience. You can you can raise your hand, Shunin. I'll go ahead and or either type it in the chat. Okay, we have a couple of questions here in the chat room. So I will, the first question that we have it is directed to Dr. Karmala.
Yes.
No, it's from, I think it's from Tasho Tenzin. Whether I think, Doctor, even you are visible to that chat, Mula.
Yes, I saw.
Interesting to know. It would be interesting to know on what ground the High Court set aside the arbitral award in PN versus MOWHS cases.
In this case, one of the so to respond to Dasho's query, one of the factors that was considered not sufficient to explain for the delays in the project implementation was that the unseen event, like the need to dismantling electric poles while constructing the road, the High Court thought that this was not sufficient explanation, and so long as there was a delay, and if that delay was not excused, and if knowingly if awarding of what was not due was awarded, then of course that's against the whole idea of public policy, the unruly concept of public policy. More specifically, the High Court said, that under Section 30 of the Arbitration Act, even the arbitral tribunal must try to resolve the dispute within the terms and condition of the contract. In this case, the High Court felt that the consideration of the arbitral tribunal not to impose liquidity damages on the contractor was outside these contractual terms, basically outside the jurisdictional reach of the arbitral tribunal. In short, this was some of the reasoning. I hope I answered your question, Dasho.
Yes, because in my presentation earlier this morning, I have mentioned that when the parties file a petition before the High Court against the decision of the arbitral award, I haven't seen any of the grounds which were provided under the Section 150 of the Act was not specifically mentioned by the parties, nor it was insisted by the court's law. So therefore, I thought these are some of the reasons, because there are some inherent problems or defect in the way this arbitration, the entire arbitration system is functioning. So I think I agree with Dr. Karmasring's opinion on why the court has invoked some section or its general power of review over the arbitration tribunal's decision. Thank you.
Yes.
Now we have one hand raised out here from Madam Sonam Yangdin. So Madam, you can go ahead.
Thank you, Migmala. My question is to Sakamala.
Yes.
Sorry, I thought the tea break was about 30 minutes and then I missed half of your presentation. But
yes.
Luckily, I got to catch you in last 5 to 6 minutes. Yes. In your presentations, I have yes, it is true that then the payment system and all are like specifically have to be underlined and like clearly specified in the contract clauses. However, like through my experience of having handled few construction cases lah,
Nice.
during the execution time lah, execution of the work at site, we observe like so many verbal instructions and adjustments happen lah, whereby it is out of their contractual obligations and all lah. So that was one of the one of the major cause of legally not fulfilling the contractual obligation by both the parties lah, both
Yes.
the procuring and the contractors lah. And at times like while in the legal battles, while we handle this kind of cases, we have to also invoke the principle of natural justice to seek the payments on behalf of the contractors lah. But
Yes.
however, we can't actually get with that lah. So if you could share a few of your like your opinion or whatever you feel on this lah, how do you have this kind of case come up to Supreme Court? Because like I have actually appealed one case on this, and this might come to you also, sir, but then like have this kind of case come before the Supreme Court before, and how have you handled on this lah?
Las Karichela. I can understand your problem. Perhaps because I don't have to do this kind of work. Probably I'm not able to relate with what you say, but as a legal person, when an allegation is put forth before the court, what do we look for is an evidence memo. So if you are saying now during the course of your business, if you had to do something on an oral instruction, and if because of that, if a problem arises, then what you or I will have to look in contesting that allegation is to produce something in the form of evidence. So I think my Dashu Tenzin will like to have an opinion on this. I think some things which you cannot put in the forms of evidence, I think it's quite difficult to plead before the court, because otherwise, if a court, even for the courts or even for a person to act on something that doesn't have a basis, it will amount to an arbitrary decision, arbitrary opinion, arbitrary statement. So I think probably our Dashu Tenzin might like to share some perspective on the kind of evidence we can produce before court. Essentially, I think this is a question related to evidence. Dashu?
Last, the only question is that Sonam, your question such repeat biname. Sorry lah.
Perhaps I should have asked Madam Sonam if I got her question correct. Perhaps.
Yes, sir. Like actually, what sir related to is also right. Like every case we go to the court, we have to back up with the evidence, mola. And then like like my question, I relate it to your presentation, the payment the mostly in this kind of post award dispute, like broadly we divide the procurement or the construction cases into two types, pre-award dispute and the post-award dispute. And post-award dispute it rotates around that rate disputes, payment system, and imposition of defect liability, and this rotate with the so especially on the payment side, though like every payment system on the additional item or the deviated item, whatever it is, though the instructions are given clearly stated in their contract, at times they also go and they have to perform the work on the verbal basis, the verbal instruction basis, and they have to adjust the rate over one another on the verbal instruction basis, and at times like on the email basis, whereby the site engineer or the project engineer, they agree at the site, and then the contractors, they perform it fearing that their bills are stuck. So when at the end, when the case come to the court, it is about at times more than a year or two after completion of work lah. And then by the time we go to the court for this kind of cases, we have to invoke the natural, like we have the evidence of the execution of work lah. So that's where we invoke this natural principle of justice, whereby the payment for the equal pay for the equal work have to be done, given, say, though it is not mentioned in the contract for this particular item, that it doesn't fall under the scope of the contract lah.
Oh,
But then the work is being done, say lah. So we back up with some circumstantial evidence or some direct evidence, but somehow it is not in the primary or the primary contract that is being signed between the parties lah. So the court give site na legadi consideration bedoga singai question the anna didi la it nation the chicken also ram ya sila.
Thank you lah. Maragi hakoto zumbo watching now. On the one hand, we have a written contract agreement between the procuring agency and the contractor, and on the other hand, we have this verbal agreement arrangements among during the time of execution. So, if there is a escalation of project key and so you consider so I think even for that matter, whether the dispute is before the court or whether it's before the administrative tribunal, I think it has to be guided by certain applicable laws. And for that matter, I think the contract agreement between the parties is the basis of the law, which is basically called the conventional law. So I think first we will look at what the contract says, more terms and conditions, the written contract. So if there is any clause in the contract, original contract, which gives the parties a leeway or freedom to amend or modify the contract, then definitely yes, we'll take up the evidence as a the subsequent arrangement between the parties as a modification of the prior agreement. But if not, then unless it's proved otherwise, I think it would be little difficult to consider the verbal arrangement that's made between the parties as an evidence unless it is proved as per. Then I think these verbal agreement also has to be based on the applicable laws, which is the Contract Act of Bhutan, whether there was a valid, whether it's a written or verbal. And if the original contract agreement dictates that any modifications or change has to be in written format, then probably even if you prove that there is a verbal arrangement, I don't think the court will appreciate your verbal arrangement, the subsequent verbal arrangements. No,
Thank you so much, Latasha. Thank you, Ma'am Sonam. So again, we have one more question to Dr. Karma. It's in the chat box session from the IDBHU-Hindubla. Dr. Karma, it says like, what would be the best possible solution to 10% liquidated damages if it is found to be ineffective tools that is used in the current procurement process?
Yes. Nice. Through the case decisions, I propose an idea that LD might be inefficient tool in managing the delays. Perhaps considering the past performance as a contract evaluation indicator that was mentioned by Professor Yukin yesterday might be of some help in dealing with the delays. Whether this past performance as an indicator, evaluation indicator, will work in the context of Bhutan will of course be an issue of comparative law in the sense the transplantation of external ideas into our context. But I think to some extent this will help in managing the delays, because if we have some weightage based on the performance, I think they will be prompt, they will be encouraged to perform and then try to complete project on time, say Nomela. And I'm also listening to the previous presentation. I'm aware that we are moving from the best price model to the mixed of price and quality model, quality assurance model. I think we might want to take this, consider this seriously. So I think we could look at how the US government use this past performance as a contract evaluation indicator and see if that will work at all in our context, and also design our price and quality assurance model more comprehensively so that the contractors will be encouraged to perform Sonomela. I think if LD is not good at managing the delays, we might have to think beyond the financial penalty that we just impose them currently lah. Ani no samtang lah.
Yes, lah. Thank you so much, lah. We do not have anyone raising the hand right now. Okay, lah. Sonam sir, lah. I'd like to share a question out here with you, lah. As you have mentioned about the challenges that you have faced in the procurement field in terms of like contract management, where you have mentioned about the timely intervention or monitoring issues that the the agency faced in all these things. Yes, we had lots of news cover. It's a hard question, sir. We had lots of news cover with regards to the Timbu Thomde as well. So how is the procuring agency now evolving or bringing a change towards this monitoring management of this contract? Is there any plans or strategic put across?
Thank you, madam. Now we have come up with a certain mechanism. Before, there is no such monitoring system in all, and now which coming, as madam has mentioned, many news coming on these procurement issues at Timbu Thomde. Now our management has come up with the project technical team, which we timely visit the field and make our site engineer to present, and if anything to be done, we are doing all the corrective measures there only now. And both physical and financial report, it's mandatory, one of the mandatory things that they have to present to the tender committee. Thank you, ma'am.
Thank you, Sonam sir. Sonam sir, thank you so much. I'll take this last question from the audience. We have Tandin Doji sir raising the hand. Sir, you can go ahead.
Last, it's not a question. Mapa Sonam Salu stations on some of his issues. So before that, on Madam Sonam Yangden's issue, Mapa, just for information, Mapa, that this especially these issues are a unique investigation way that where the contractors, the site engineers issue some verbal order instructions, and then they are made to do the works, and Shulet Telen there are disputes regarding ani kashlo the payment gita madu themela, but ngachi khatuledi while we create awareness, we always focus contractors ngachi kashlab dogo so achin number birula instructions the written nara any communication that written nara bego simidi anidi namasami shouldn't the decision win la. And in fact, even the agencies ki what they do is they'll during the tender committee meetings they'll do a lot of discussion and to arrive to a particular decision they would have all the valid reasons but ultimately these are not captured in their minutes and records, and then this leads to audit observations at the end of the day So Aniputal, we always now in fact in our SPR we have specifically mentioned that it is mandatory now for the agencies to maintain records, and moreover, contractors awareness we always focus that number beru communication the written get focus and on the three suggestions to Sonam sir firstly on the delay which is caused by the standstill period just an observation what agencies tend to do is that of course there's the 10-day standstill period in the PRR which has been reduced to 2 working days in the SPR But ngachi ani jeta the lugachpio me so firstly agencies accept grievances beyond this standstill period la. So even after 10 days or be it 2 working days kishule grievances accept biomela. And secondly, the tender committee as the first tier grievance redressal body, they're supposed to issue only one decision la. But what happens is that the bidder would put one complaint, again the agency will issue a decision, again the same bidder will respond to the decision taken. So in that way the whole process gets delayed in the decision la. But strictly going by the instructions and the bidding documents, Sachi, if you all have issued the decision, you'll stand by it. And in case he's not satisfied with the decision, then he would appeal to the next appropriate body session. And on the second issue, where you'll face particularly in small contracts. So, Anina Theka Hidalu, of course, price generally agencies take only price into consideration la. But Nabugi, what you all can do is you all can use the other evaluation criteria la. Like suppose there's some manpower requirement, some financial capacity requirement, or some equipment requirements. So again, these are tools whereby you can actually help you in carrying out evaluation session. And Jura on the front-loaded bids. So front-loaded bids, sir was mentioning it from contract management perspective. But these front-loaded bids, like abnormally low bids, should have already been addressed during the evaluation process. So what during the evaluation process, so the contractors, they try to play smart. So in the items in the BOQ, if the items are profitable items, they tend to quote higher. And for some items in the BOQ which are not very profitable, they tend to quote turuni quote bionla. And then while executing the works, they would perform all the profitable items in the BOQ, and then the non-profitable items go hivnale contract terminate to bella. So basically all the profit would have already been generated from those profitable items. So during the evaluation process, it is very important to go through the BOQ, and if there are such cases are there, then I need to scrutinize the process team of Himalaya session. Thank you.
Plus thank you so much Tanjin sir So this is an obligation session Garalo. So thank you so much for attending the 8th session, the end of the day, and it must be a very trying day to everyone. Now, before that, I would like to hand over the floor to our MC for the day, Ms. Hewang. Thank you so much, everyone.
Thank you, both the speakers and the moderator, for this another round of very informative and interactive session. With this, we come to the end of today's program, and I would like to sincerely thank all our able speakers and the moderators for your inspiring, intellectual, and very interactive session. I'm hopeful that the session was equally interesting to our valuable guests who are with us virtually today. Thank you all for joining us today, and we look forward to your same support for our final day tomorrow with fresh set of keynote speakers, presenters, and the moderators. Katinchela, and have a wonderful evening.